Hello, folks. Welcome back to the Wikipedia world, and I am Abhinay Gupta. So today again we'll be continuing with the winding up of the companies. Right? Don't worry, we have completed almost all the sections of winding up, the entire procedures of winding up, the three kinds of procedures that we were talking about. Right? That is either the compulsory winding up by the court, the voluntary winding up by the members or the creditors, and the voluntary winding up subject to the supervision of the court. Right? Now there are a few other concepts that I want you people to know that you should understand, because even that is very important from your exam point of view. Right? Now, for example, if we talk about the defunct company, right? That is one question that has been asked 5 to 6 times in your examinations already. The kind of questions that you are asked for defunct company is, right, what are the effect of striking off the name of the company? Right? Or how can a defunct company be dissolved? Or it will give you a case study and explain in the case study that yes, the company is a defunct company, and then it goes on to ask typical questions from the provisions of the section. How can it be dissolved? What will be the time period? Who is authorized, and this, that, all sorts of questions over there. Right? So the topic of today's lecture would be the defunct company. We would understand the provisions that are related to the defunct company under section 560. Over here I will say that the section is important. Why? Because in the past, if you refer to the questions of the institute, there have been questions where institute has directly asked you to give your answer with provision to section 560. It nowhere uses the word defunct company or something. It says striking off the name and then refers to section 560. So it is important for you to recognize the section in your examination as well. Right? So just remember, it is section 560 of the Companies Act 1956. Okay? So we'll start with the discussion of the defunct companies. So basically, when we talk about the defunct companies, what is the first thought that strikes your mind? What kind of company is this? Yes, when we say it is defunct, that means it is defunctional. The company is not functioning. It is dead. It is silent. Right? No operations, no creditors, no debtors, no liabilities, no assets. They have, like, it is not occurring. No more liabilities are being added, no more assets are being added, no operations are being taken place, no employees, no management, nothing. We don't know what has happened. But the only thing that we know is that there was a company existing, we had certain products in the market, or we had certain services in the market, and now we don't see any of it. But if we go and refer to it, the name still exists in the register. That means the name is not struck off. The company is not yet dissolved. The only thing that has happened is the company has stopped functioning. And you know, when the company stops functioning, when the company wants to stop its operation, wants to put an end to the company, they should be going through the entire procedure of winding up and then dissolving the company. Why? Because there are stakes of people that are involved in the company. The shareholders, they have invested their money. The creditors, they have given their resources. Right? The providers of finance have provided finance to the company. There are a lot of people, right, whose money is at stake with the company. So if any company at any point of time wants to move out of the market, wants to put an end to its operations, to its function, to the existence of the company altogether, then that company should follow the process of winding up. Right? Either it is a voluntary winding up, if you want, by the members or the creditors, and if no, then somebody should file a petition and take the company for the compulsory winding up. But what has happened in the case of defunct company? Nobody came up voluntarily to wind up the company, nor did anybody file a petition. So when nobody files a petition, we are pretty sure that okay, there is no big deal. That means there are no big creditors whose lot of money is involved. Nobody is having any issue. There are no providers of finance who has given loan to the company and is now struggling for the repayment. So we are assured that okay, certain situations are not present over here, because if those situations were present, please try and understand, then we would not have called that company a defunct company. The company would not be dead and silent. Why? Somebody must be continuously poking that company. Dude, I want my money back. When you wanted it, I lent you the money. Right? Now I want it back. And you just can't stop your operations and be silent. If you don't give it to me, I go to the court. And when I go to the court orders compulsory winding up for the company. Then the official liquidator comes, he sells off all your asset and he will pay me back my money. So it's better return my money. So maybe the defunct company, the company that has stopped functioning, they give out some of the money. Okay, do one thing, keep 90% of your claim. We don't have a lot of money with us. And that again, that big provider of finance or that big creditor goes silent. And the other, there are minute creditors, they don't come up. Right? So if you understand with the entire scenario, then defunct company is one company that has stopped functioning, that is dead, that is not available, that is not present, that has no existence in the market, as well as that company is not hampering the interest of the public or hampering the interest of the people who are concerned with the companies. That is in general, right? That is what we will construe out of it. That is what we will understand out of it. Because if somebody had a problem, they would have approached the court so far. Right? So that is the kind of company that we are talking about. So let us see what are the provisions as per section 560 that is used to strike off the name of such company. That means over here we are not undergoing the process of winding up. Remember that. We are following some other process to bring an end to this company. We will just straight away, when we studied the winding up provisions, when is it that the registrar strikes off the name? It is after the court has ordered dissolution and that copy of order has been submitted to the registrar. It is then when the registrar strikes off the name. So the entire process of winding up, the entire process of dissolution, everything comes to an end, and then finally when the report is transferred to the registrar, it is then when the registrar strikes off the name. And over here in section 560, we will try and understand the situation when the registrar strikes off the name without going into such procedures, without getting into the procedures of winding up and the dissolution of the company. Right? So since over here we are trying to see how the registrar or when the registrar strikes off the name without following the procedure of winding up and dissolution. Right? So we must see that even the registrar should be confirmed that yes, the company has stopped functioning. The company is no more in existence. It is mere in the names and mere in the records. So we need to strike it off from there. We don't need clutter over there. We don't need unnecessary clutter over there. Right? So how does the registrar confirm this? So let's see the procedures followed by the registrar. So on your screen, the procedures followed by the registrar for confirmation that the company is not carrying on the business. So when the registrar thinks that yes, this company has stopped functioning, we are not hearing a lot about this company. No accounts are being submitted, no statements, no balance sheet is being prepared. Nothing is happening. Like we are getting no response from the company. We are seeing no activities in the company. Neither is the product in the market, neither is there any services provided by the company, nor is any statutory liabilities being undertaken, nor the statutory statements, statutory meetings are being undertaken. Nothing is happening. It is pin drop silence in the company. So the registrar is also curious. What is happening? Is there an issue? Is the company still existing? Is it working or has it stopped working? Now how does the registrar know? The registrar, he needs to confirm before striking off the name. It's not that okay, we are hearing nothing of it, nothing is coming up, no correspondences are coming up, there's nothing in the market, let us strike off the name. No, that is not the procedure. The registrar has to be confirmed that yes, the company has stopped functioning. Because maybe the company is functioning, maybe they're taking some time, they are into some research and development, maybe they are involved somewhere, they're not able to do it because of any reason, right? But still in the background they are struggling. There is a possibility, right? So the registrar straight away cannot strike off the name. So what does the registrar do? The registrar in the initiation of this process sends a letter of inquiry to the company. Right? And write a letter that okay, as per what we understand with the current situation, of your company in the market, and with the activities that you're doing, with the legal activities as well, we are not sure whether or not you are functioning. So it is not necessary that the company is not even following the statutory requirements. Maybe there is again, that is one situation where it is the drastic case. No statutory meeting, no functions, no operations, nothing. But again, if you see in that situation, right, if they are not able to hold the statutory meetings or file the statutory report, then even the registrar can go for the winding up procedure as well. Right? It can file a petition to the court So basically what we think that okay, if they are not, if to that extent they are defunct, that they're not even being able to get to the statutory liabilities that they have, then the registrar will not strike off the name, he would apply to the court for liquidation, for winding up of the company, right? So let us consider it this way, that the company has just stopped its operation, right? The statutory dues and the statutory meetings and the reports and all, it is not a very severe case so far, that the registrar not to that extent that the registrar should go for winding up, maybe anything less than that. They have defaulted in meeting, there is a possibility, right? So whatever is the situation, let us not get into that. What we understand is that unless and until situation arises for winding up the company, over here neither the registrar is going for filing the petition, nor the creditor, nor the contributory, nobody. That means the company has not impacted anyone. There's no impact by the company on either the registrar or the creditor or the contributor, anybody. No, nothing. The only thing is they are not in operation. They are not functioning, right? So we will take it to that extent only. That is when it is a defunct company. If it goes beyond that extent, if something is very massively wrong, then somebody would have ordered winding up. Somebody would have filed a petition for winding up, right? So the registrar will send a letter of inquiry. But listen, as per what I consider is that you people are not carrying on your business. I don't think you're producing anything or you're selling it off in the market. Is it so? Please respond. Are you people still in office? Are you people still working? Are you still procuring the raw materials? Are you still into the process of manufacturing? Or if you are not a manufacturing entity, are you still providing your services? Or are you still into operation for whatever you are doing? That is a letter of inquiry the registrar will send. And the registrar expects a reply in return. And this is a very casual letter. It is just a letter of communication. That okay, we think that you're not in operation. If you are, just let us just inform us and we are okay with it. No problem. Carry on. It is just that I am suspicious whether or not you are carrying on the business, because I hear nothing about you in the market. Right? That is what the registrar will say. It is just a formal communication for an inquiry. Nothing else. It is not any legally enforceable document or something, right? It is a formal letter. That yes, I need certain information, give it to me. Now, if the company replies and says that yes, we are into operation, or this has been the issue, or there has been some problem, whatever it is, but we are still into operation. When will the company reply? When they are actually into operation, because when they receive the the letter at the registered office, they are replying. That means there are employees sitting over there, there are management sitting over there. So people are still functioning, the people are still working, right? So even that is an assurance for the registrar that okay, they have not closed the company yet. They are working. They are still sitting over there. They are trying to figure out things, right? But what happens if the registrar does not receive a reply? It is a very rare situation that it receives a reply that okay, yeah, we have closed. No, because nobody can say that we have closed, because there are legal proceedings, there are legal procedures that you have to follow before closing the company. So no management will ever reply that yes, we are closed, right? Either they will not reply because there is nobody, they are actually closed, or they will say that okay, no, we are still into function, we are trying to figure out things, there have been some problem or something, whatever it is, right? And if there is no letter, that means the registrar is not suspicious. It's been one long month, I have sent the letter of inquiry and I have not received any communication from the company. So there can be two situations. One, there is nobody to receive the letter, nobody has seen my letter, nobody is there to respond, that means the company is dead. Two, nobody has bothered to do it. Why? Because it was just a formal communication. You said, oh, it's a letter from the registrar, what has he written? Avoid, keep it in the desk, I'll see it later. That can be the attitude of the management, because it is not a very important document. Important as in it is not legally enforceable document. It is not a notice, right? It is just a formal letter. So they can be negligent, they can be lenient on that end. So even that is a possibility. So before taking any further step, what the registrar does is that okay, even the registrar will consider maybe they did not receive it, maybe they did not pay attention to it. So let me give them a little stronger document, right? Then the registrar sends them a registered letter. He gets a letter registered that okay, this is the letter I'm sending to the company, and it is a formal communication to the company with an intent of getting a response, right? And this registered letter should be sent to the company within next 14 days. 14 days from 14 days from the end of 1 month period when it had sent the letter of inquiry. So for example, if the letter of inquiry was sent on 1st January 2015, then the registrar will first wait up to 31st January, 1 month, right? And nothing is received. Then 14th February, yes, the Valentine's Day, 14th February is the time within which the registrar will have to send the letter of the registered letter. Sorry, it's not letter of anything. Letter of inquiry had been sent earlier. Now it is the registered letter. That listen, I had sent you a letter, a formal letter, but you did not reply. So please consider this to be a little serious matter, right? I'm sending you a registered letter. Please reply. And if you do not reply, if I do not, this time he'll give them a warning that you have neglected me in the past. Now if you neglect me, now if you do not reply back to me within 1 month, right, then I will publish a notice in the official gazette that I intend to strike off your name from the register. So if you do not reply me back, I will issue that notice in the official gazette, and everybody will know that yes, your name is going to be struck off. And if you are actually functioning, then that will be a very big impact on your goodwill, right? You will lose the creditworthiness in the market. So be rest assured, take my letter seriously and reply back if you are there. Then suppose 1 more month passes by and the registrar does not receive any communication from the company. If it had received any communication and the company says, okay, we are sorry, we did not pay attention to your letter over there, or we just missed it out, we are so sorry for that, we apologize, and we say that yes, we are in operation, we are there, please don't strike off the name, don't take any action for that. And they'll attach some proof also that okay, let's see this is our working, this is what we are doing, and they'll just narrate a little story that yes, we are functional, please don't take any serious action, go off to sleep again, right? Forget about our company, we are in operation. Then the registrar will again sit silently, okay, they are in operation. But if the registrar does not receive any information within the next 1 month also, that means the registrar thinks, listen, see, I had given them a warning, still they did not bother to reply. Or there is the next case that there is no one to reply. Or the company replied within 1 month that yes, we are not operating. There has been some issues and we have stopped our production, we have stopped our operation. So we are not operating anymore. Tell us what to do. If you want to strike off the name, strike it off, no issues with that. Right? There can be either the negative communication or no communication. In both the scenario, the registrar, if there is no communication, will wait for 1 month, and if there is a communication just the next day after the communication, after the negative communication, he can issue a notice in the official gazette. Right? He shall publish a notice in the official gazette. And what will that notice say? That notice in the official gazette will say that if the company is not able to show any cause for the action or for their no action for the past some time, for the past some period, for my letter of inquiry, for my registered letter, if there is no response, then still I'm giving you 3 more months time. Either you come back to me and say that okay, this was the issue and that there has been a problem, I don't have an issue. Otherwise, I will strike off your name with the end of the period of 3 months if you do not revert back, right? And that notice, which is published in the official gazette, will also be sent to the company at the registered office via a registered post, right? Because the registrar wants to make sure that the company is receiving that notice. People may not see the official gazette at time, but if the notice is going to their office in hard copy, in hard document, then they will definitely see it. And again, then if they do not bother to reply, I will strike off the name immediately. Right? So here basically what do you understand? When does the registrar publish that notice in the official gazette? 1, if it does not receive any reply within the period of next 1 month, and 2, if he has received a negative response that yes, we have stopped the operation, we cannot continue further, right? Whatever be the case. So some of you must be thinking that okay, if we did not receive a response, we are giving them 3 more periods of time to respond. But if we have received a negative response, then what? Then the company will just issue a notice in the official gazette that yes, I am going to strike off the name of this company because it is not functioning. Right? If there is no response, it will give them a 3 months period also. Otherwise, in the two situations where it has received a negative response or that 3 months period has come to an end, the registrar will simply strike off the name of that company from the register of the companies. Right? And then again publish a notice in the official gazette that yes, the name has been struck off. The company is no more into existence. And with that striking off of the name, when the registrar informs everybody that the name has been struck off and the registrar actually strikes off the name, as a conclusion of it, the company stands dissolved. Right? With that striking of the name, the company stands dissolved at that point of time when the notice is issued or when the name has been struck off. Right? So basically, if we see what has happened is, first, to start with, the registrar had sent to the company a letter of inquiry. It is a formal document, a formal communication that, listen, I doubt that you people are into business because of some reason. Please just let me know whether or not you are into business. There is no legal action being taken. And if the company does not respond in the period of 1 month, then within the next 14 days, he will have to register a letter and send it to him. That now I'm sending you a registered letter, take it seriously and reply it back. Now it's a serious issue. Even then, if the company does not reply in the next 1 month's period, then it will issue a notice in the official gazette. That again I'm sending you a notice, and if you do not reply in the next 3 months, I will strike off the name. I will not give you any further warnings. And then again, if the company does not reply in the next 3 months, there will be another notice issued in the official gazette that the company's name has been struck off. So that publication would be that it has already been struck off. The company is not into existence as per the register of the company. The company stands dissolved. Right? So what is the total duration? So once the registrar comes to think that the company has stopped functioning, there's first 1 month time for the letter of inquiry, plus 14 days for sending the registered letter, plus 1 month for the registered letter, that is 2 months and 14 days so far, plus 3 months after the notice in the official gazette. So it is 5 months and 14 days the total period. So once the registrar comes to know that the company is not functioning, then within the next 5.5 months, the company will stand dissolved. That is the maximum period. Right? Otherwise, if within that the company is able to prove that we are not a defunct company, then the provisions of section 560 is not applicable on that company. The company continues. Right? So that was the entire concept of the defunct company. How does the registrar confirm that the company is a defunct company, and what is the action that is being taken? Right? So I hope that is very well clear with you. The only purpose of this lecture was to inform you as to the procedures and the rationale behind the defunct company. Right? So with that, we'll put an end to this lecture today, and we'll continue with the provisions of defunct company, the other provisions of defunct company of section 560 in the next lecture. Right? So this lecture was specifically focusing on what is a defunct company and what is the procedure taken forward by the registrar of the company before striking off the name, or for striking off the name of that defunct company from the register of the company. Right? So please stay tuned for the next lecture. That will be a continuing lecture to this topic. So until then, this is Abhinay Gupta signing off. Thank you and bye-bye.